So one of the things I mentioned the other day that I was going to try to start focusing on is the various stages of litigation in a personal injury case. When I say personal injury, I mean car wreck, slip and fall, trip and fall, medical malpractice. But you hear lawyers talk about the intake process, and what that is when clients call you, or potential clients call, you're going to want to get, it's pretty basic stuff. Their contact information, where they live, cell phone number, email. You're going to want to get their date of birth. You're going to want to get information about their medical providers, stuff you could do potentially in an initial interview, but you want to get the date of the injury, where the injury took place, if they have a copy of the accident report, if they know, if they don't, if they know who hit them and what their insurance information is. You want to get the insurance information of the potential plaintiff, which is the person that in theory would be filing a lawsuit if there were a lawsuit, or just pursuing a claim. And so that's all really important information to get. You also want to try to get, whether or not the person's been involved in any other litigation, whether or not they have had previous surgeries, what their previous medical treatment is, if they have copies of their previous medical records. You're going to want to get all that. And that's going to be done very early on. It's very important to determine what, if any, your potential plaintiff client had in terms of any fault. North Carolina, if you're in any way at fault, you can't recover due to what's called contributory negligence, which is a defense that can be asserted, an affirmative defense that can be rebutted to some extent. You can show what's called a last clear chance, which is another way of avoiding negligence, if the defendant trying to avoid negligence, ways that they could have behaved. But that can get pretty nuanced, and you don't want to have to fight off a not last clear chance response to a contributory negligence defense. But the pre-suit stuff, the client intake stuff, that's like the very, very early stuff. And then there's some pre-suit investigation, which is really the next phase. But the client intake process is really important. That's where you determine to what, really how good a case is, quite frankly. Early on, you can tell. You can't know everything because you may not have the medicals. If they have the medical records, current records, that's going to be very helpful. The more information you can get, the better. But I think it's really important that clients not talk, potential injury victims and potential clients not talk to insurance companies. You don't want to, talk about your injuries or anything like that. You generally do need to talk to the police, obviously your medical providers. But it's, if you're ever in a wreck, you obviously have to call the police to get them to come because they're a good third party,